Hey guys, so after Lively filed her unhinged 4-page bitch fit over the affirmative defense of mixed motive earlier, she has she has filed another letter. She's seeking leave to file a letter, and I'll just look at her letter in a moment. But just to catch her up, in regards to the unsealing. So the judge has now ordered that everything be unsealed. That's things that Jed Wallace and Katie Case, I think it's Katie Case, wanted to be kept under seal. He has said basically no to that because Wallace wasn't actually engaged by those clients. So he said, well, there's not really any privacy issue here because they never retained Jed Wallace or Katie Case. And save for a few items of personal identifying information on the documents that Betty B. Holdings identified, he's just said, everything now gets unsealed, which is fabulous. So let's go to this letter from Lively. It is just really brief. Dear Judge Lyman, on behalf of Plaintiff Blake Lively, we write pursuant to Rules 1C and 4C of Your Honour's individual practices to respectfully request leave of this court to file by May 1st, 2026 at 5 p.m. a letter brief of no more than 5 pages in response to Wayfarer, and it ends with us, letter dated April 29th, informing the court of their agreement with respect to the protected activity element of plaintiff's fourth cause of action. So that's the stipulation that, for the purposes of the trial only and in no other context, not an appeal, not on the 47 point, the section 47.1 remedies motion, not in any other context. Wayfarer agreed that the jury could presume that Lively had complained about, had a reason, that Lively had complained about, like what she perceived to be, like sexual harassment. Now, that is not conceding that there was sexual harassment. They're very different, despite what Lively supporters are trying to spin. They are not admitting anything, in fact, quite the opposite. Yes, Ms. Lively's letter brief will address her position on the agreement and her understanding and position on the implications of the agreement for evidentiary and other issues outstanding in the case. So Lively's not happy about this, is what I'm hearing. And I expect that, to be honest, because now she's going to be kind of prevented from bringing in a lot of testimony, evidence, witnesses, etc., which would have had the first few weeks, as not actually Gordon said, absolutely right. It would have had for the first few weeks just headlines kind of, hammering home Lively's version of events and what she's testifying to, what her supportive witnesses are testifying to. And then, Wayfarer wouldn't have managed to get their side of the story across, or their evidence across, for a few weeks. And especially in these kind of really emotionally charged types of cases where, sort of sexual harassment and those kinds of acts are involved, that can be, pretty difficult. The judge was very swift. This is restricted on PACER. So here it does say you can buy on PACER. I did actually try to do that. And it says the document is either restricted or cannot be found. So, but Lyman straight away denied. He does say that the court will hear the parties at the conclusion of the Daubert hearing. But, given that he kind of said to Wayfarer, "Hey, do you wanna go away and think about whether you're prepared to stipulate to this or dispute it?" I don't think he's not gonna change his mind, but I don't think it's entirely unreasonable, and this is the only point I don't think Lively's been entirely unreasonable about, is what does that look like? Like, how is that going to affect, in terms of what evidence will be admissible and what it will be excluded, how the parties can present their arguments. And we're now, very close to trial. Less than 3 weeks to trial, in fact. So, these are questions that both sides actually need answers to. So, yeah, just a very quick update to sort of catch up with these filings. But, and, with Lively's letter as well, normally they file a letter, say, "Hey, I'm seeking leave to file this letter," and then they normally attach the letter as well. Lively didn't attach the 5-page letter because obviously she wanted the end of the working day, 5 p.m. Eastern, to submit it, and Judge has come back and gone, "No." So I think Judge Lyman, though, is getting a bit kind of pissed off, and I think he's not prepared as well. I think he's wised up a little bit to the fact that, especially the letter she filed earlier on the proposed jury instruction for the mixed motive defense. Like, it was so obvious that a lot of that was written for PR purposes, and I think Judge Lyman's kind of wised up a little bit to that, and this close to trial, he is not wanting to see that shit on his docket. So, I think that's why he's come out quickly to say, absolutely not. But we'll see, because obviously we've got the hearing. So I'm sure we'll find out there what Lively's grievances are.